It might just explain why attorneys went at each other in what might be called a feeding frenzy that just pushed those limits of what we call professional courtesy. Hello, I'm James Curtis with the Bad Attorney Jokes. Welcome to E's coverage of the Michael Jackson trial. And before we get to that lawyer versus lawyer showdown in the courtroom, we pick up with defense attorney Tom Mesereau's cross-examination of Dr. Stan Katz. Now, you'll remember Dr. Katz is the clinical psychologist who interviewed the accuser and his family before the charges were filed against Michael Jackson. Now, if you're counting, this witness is the second child abuse expert to testify for the prosecution, and this is what he told the jury, according to the courtroom transcripts.
When you were interviewing the did you do any background check into their involvement in any other litigation?
I did not.
Did you ever check into any allegations of domestic violence in the family?
I didn't check into any of these allegations. I did not investigate any of these allegations other than, other than to interview the parties. So I did not do any investigation of any allegations.
You talked about a number of situations where parents consistently told their children they've been abused, and the children believed it. And in your opinion, there had been no abuse at all, right?
Well, and that specifically is regarding young children. We're talking about children under the age of 5 years.
You are aware that there can be all kinds of motivations for false claims of molestation, correct?
Certainly there's a possibility of all kinds of claims and reasons.
You're aware that alleged victims of molestation often sue for millions of dollars in civil court, correct?
That is correct.
Next, the question of the ages. What came first, the cops or the legal counsel? A program note, the Bill Dickerman you hear referred to as an attorney who represents the accuser's family. He takes the stand a little bit later on in our coverage.
Clearly, it was always your understanding that the first went to lawyers before they ever went to any police office, correct?
It's my understanding that they went to attorneys before they went to the police department. That's my understanding.
And was it your understanding that they first went to Attorney Dickerman before they went to Attorney Feldman?
Yes.
Now, you have indicated that you were retained by Attorney Larry Feldman to work with him on his civil suit that he filed against Mr. Jackson in 1993, correct?
That's correct.
Was it your understanding that Mr. Feldman was in contact with Mr. Snedden in 1993?
Objection, lack of foundation.
Overruled.
I have no information about that at all. I don't have any memory of that, any information about that.
Enrique Kleeman, we covered this witness initially yesterday, and we talked about the idea that he has a relationship with Larry Feldman. Apparently, relatives of Larry Feldman have continually referred people to Dr. Katz, so that's a bias issue. But here he talks about not really talking to the kids to determine whether or not they're telling the truth or not. That seemed a little odd to you?
Well, what he does is he says he's just hearing out their allegations in this particular instance, that is against Michael Jackson. So he's not looking back. Therefore, he's not finding out about the JCPenney suit. Therefore, he's not finding out about allegations of abuse against the father. So in order to make an evaluation, I would think of a child who says he's a victim of abuse. Wouldn't you want to know that background information?
It would seem to me, Howard, that at least for the purposes of what we all know to be malingering, that psychological or mental health professional term that we get from the Bible, the DSM-4, the Diagnostic and Statistical Manual that the shrinks use, that is faking it, you would want to know if these kids are telling the truth.
Yeah, I would hope if I sent somebody to a therapist and credibility was part of what I wanted to determine, whether they're being truthful or not, that a professional would go into the background and delve into years prior. That, for example, they'd want to know if there was any abuse. They'd want to know if there was any other problems that they had with the family or outside the family. I think it's very odd and candidly not believable that he just tailored all his questions to a very narrow area.
But you know what? But exactly.
You're right where you were
That's
going.
right. It is believable because there's this connection. And Mesereau does a brilliant job, I think, of laying out this connection, which is the connection between Snedden, Feldman, and Katz, which equals get Michael Jackson, make lots of money.
Now, is that a fair comment, though, given the fact that this witness does talk about wanting to make sure, as all psychologists do in this situation, about the motivation for bringing this kid to him. He talks about that.
We cannot be naive. He
well, we can. It's just not pretty.
Okay.
Go ahead.
Especially on you.
Thank you.
He gets referred, this young man, from an attorney who is renowned for successful, suits against people.
And particularly
Michael Jackson.
Michael Jackson is
money,
synonymous.
successful suits, and we'll discover
Doesn't take
and
a
explore.
genius to figure out what's going on here.
Indeed, but luckily we have Howard Weitzman, who is a genius. On redirect examination, does Assistant District Attorney Ron Zonin hear exactly what he wants to hear?
What is your understanding about the percentage of false allegations in those types of cases involving older children?
Well, my experience, my clinical experience, my collegial experience, is that there's very, very few false allegations made with alleged perpetrators outside the family by a child over the age of 5.
And involving specifically allegations of sexual abuse involving boys, adolescent boys. What are the difficulties involved in making a false allegation or sustaining it?
Well, a pre-adolescent or adolescent boy is hypersensitive about his sexuality. It would be extremely unusual for a child who's developmentally at a stage where he's trying to figure out who he is and to actually become a man to make an allegation which would suggest that he's had inappropriate sexual relationships with a male. It would be extremely rare because these children are so protective and so guilt-ridden and shamed by any behavior that's extraordinary and extra-normal. So it would be highly unusual, in my experience, for a 12 or 13-year-old to make false allegations regarding a male perpetrator.
Now, Sean, intuitively, that seems to make sense.
Intuitively, it does make sense, and I think jurors often reject experts because they know that the prosecution's going to have one expert that says one thing, the defense has got to have an expert that says the opposite thing.
Have opinion will travel.
Right, right. And so the jury just really has to rely upon their common sense in evaluating what makes sense.
But will
and I think
they really
this does
do
make
that,
some
though,
sense.
Howard, to the extent that the area of psychology and how our minds work is something, although we can have indications based on our life experience, and we've got some substantially experienced individuals on this jury, people do tend to sort of give the nod to the expert when it comes to the mind, don't they?
I'm not sure at all, but ultimately it depends on whether or not they believe the young witness. Period, paragraph.
And it really goes as corroboration of the young witness. I think that people do not know a lot about child sexual abuse and sexual molestation, and I think jurors would like to know. But if Sean is correct, and I believe she is, that if the experts cancel each other out, let's assume that Tom Mesereau brings in the wunderkind expert. If they cancel each other out, it still goes back to, do we believe young Gavin?
Now, people don't know, actually, as we all know, a lot about child sexual abuse, but do they think they know a lot about child sexual abuse? In other words, is the popular opinion that, yeah, we understand this happens and we kind of know how this works?
I still think the whole subject is not popularly recognized or known. Okay. People read about it, they have images, but I think most jurors quickly understand they don't really know about it.
And they're open to learning.
Yes, I think that's true.
And we'll see how that plays out in this courtroom, as we will certainly see more experts take the stand. When we return, can the attorney representing the accuser's family stand up to a no-holds-barred attack by the oh-so-legendary Tom Mesereau? Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. As testimony continues, Assistant District Attorney Ron Zonin seems to abruptly decide that Dr. Stan Katz has given the prosecution just about everything they could want. Here's what the jurors heard according to the courtroom transcripts.
Are there difficulties in a child maintaining false allegations from a practical standpoint?
Well, in my experience, a child who's going to lie and fabricate cannot be consistent and hold that very long, because children are impulsive. I mean, they can't delay gratification. You can't tell a child years from now, if you lie, something good will happen. Children are very much living in the now. They don't maintain consistent allegations when they start feeling as if the disadvantages of making those allegations seriously outweigh any advantages.
No further questions.
So, will they acquit if defense attorney Tom Mesereau can make the testimony fit for the defense case, that is? Testimony continues with the cross-examination of the psychologist, Dr. Stan Katz.
You said something about children who are making false allegations tend to be inconsistent when they describe those false allegations, correct?
No. What I said was, in fact, it's the opposite. The children who make false allegations are usually very consistent and almost scripted in what they say. I mean, they exaggerate, they embellish, they take every opportunity to make a positive into a negative. Children who've been molested tend to be inconsistent. They have problems with memory retrieval. Their data storage is not great. They don't remember dates and times, and they don't remember exactly what happened. And they don't tend to embellish and exaggerate. When you interview these children and you ask them if something happened, they won't say, oh yeah, that happened too. They'll say, no, that didn't happen. Children who fabricate will all of a sudden tell you that everything happened to them by everybody. And so they exaggerate because they don't know intellectually when to stop.
So what you're telling the jury is, in your experience, exaggeration and embellishment can be signs of false allegations of sexual abuse?
That's correct.
Herein, Howard Weitzman, and I appreciate your congratulatory remark on the homage to our friend Johnny Cochran with the groan, but herein lies the problem for the defense. The classic, as we talked about a couple of weeks ago, the classic ammunition, if you will, to trip up a witness to see if they're lying is inconsistency. Yet this is at least the second time we've heard that children who have been molested are not consistent.
You know what? It all depends on the witness and the facts and the circumstances. Sometimes, if they're totally consistent, it looks fake. It looks scripted.
Right.
Sometimes, if they're inconsistent, the inconsistencies are small and not very material. It all depends on each individual witness and the lawyer's
But that's all we
ability to
got here, Sean.
cross-examine.
Essentially, you've got the inconsistencies, but witness after witness, or at least a couple of witnesses, have said that the inconsistencies prove truthfulness as opposed to the intuitive and experientially opposite.
And this is what I was talking about before. I really think that the jurors are going to have to use their common sense on this one, because I guarantee you, Tom Mesereau is going to have an expert who says what he wants him to say. And the jury's just going to have to ask themselves, they've got kids, some of them are former school teachers, you've just got to go with your common sense. Does this make sense what this expert is saying? I don't know.
And it depends on what the inconsistencies are, too, James. It's one thing that if you're a scripted child, and we have seen scripted children in other cases, where they literally have a paragraph when they talk about the act of molestation and it never changes, not a verb, not a noun, not anything, versus normal inconsistencies. If the four of us see a car accident, the four of us will tell the story differently from each other, even though we all saw the same accident, and tomorrow it will be different from what we told today. It's one thing, I think, for Gavin to say, I really can't precisely remember. I can't. I know it was more than twice. I know it was more than 4 times. I can't remember. But this was the general pattern of what he did.
Next, the defense says, show me the proof.
And if in any of these cases there is no physical evidence to support the allegation of sexual abuse, the decision regarding whether or not you believe the allegation is true is really a subjective one, right?
Well, there's rarely evidence in these kinds of cases. I mean, I've been involved in thousands. Rarely see evidence, physical evidence, like trauma to the genitals, for example. It's subjective evaluation based on an assessment and many data sources to actually determine what happened.
Doctor, in cases involving sexual abuse in the criminal courts, you're seeing more DNA evidence all the time used in these cases, correct?
In some sexual abuse cases, yes.
You're seeing evidence of semen, DNA, and things of that sort, correct?
In some of the cases, yes.
And if you don't have any physical evidence, it becomes pretty much a subjective determination regarding credibility, correct?
Well, there may be other evidence which is more objective. But certainly, if you don't have the physical evidence, you're missing one. The physical trauma, you're missing one piece. But sexual abuse is not physically traumatic. Fondling does not leave marks and bruises and semen.
Now to the main event, folks. Attorney Bill Dickerman takes the stand. Dickerman is the lawyer who represented the accuser's family and who referred the family to attorney Larry Feldman. Now, Feldman netted a reported multi-million-dollar settlement for another alleged victim of Michael Jackson stemming from a 1993 incident. On cross-examination, defense attorney Tom Mesereau tries to draw a little blood as he follows the money trail.
You just told the jury you have a fee-sharing arrangement with attorney Larry Feldman, right?
Correct.
And fee-sharing arrangements among attorneys are a fairly standard type of thing, are they not?
Under certain circumstances, yes.
And typically in a fee-sharing arrangement, the understanding is the following. Attorney 1 refers the case to Attorney 2. Attorney 2 files a lawsuit, and if there's a settlement or a judgment or any amount of money recovered, then Attorney 2 has to give Attorney 1 a percentage of the recovery the attorney gets, right?
Under certain circumstances, as they often are, yes.
It's typically called a referral fee, right?
There are situations where there are referral fees, and there are situations where the attorney would be involved in the lawsuit, and that's how he would be compensated.
In your typical referral fee arrangement, the referring attorney, being the attorney that sends the business to the other attorney, has an arrangement where if the other attorney collects money, he gives a percentage to the attorney that referred the matter, right?
In any strict referral fee arrangement, yes.
But what you're telling the jury is your arrangement with Larry Feldman is not a strict referral fee arrangement, correct?
Correct.
Your arrangement with Larry Feldman is that you both will share in any fees collected, correct?
Yes.
And that would mean if tomorrow or next month or this summer you and Mr. Feldman decide to file a civil suit against Mr. Jackson, you have an understanding that if any money is obtained, you'll get a piece of that money, right?
Yes.
If there's no intent to collect money, why the fee arrangement?
Well, of course there's a fee arrangement. Of course there's an intent to collect money. Lawyers are in the business of lawsuits. This is not strictly a referral fee, which would usually be about a quarter or a third. This certainly sounds like much more. It's fee sharing, and it is disingenuous to say, well, we don't know if we're going to settle.
But will that be lost on the jury? Howard, let me move on to Dr. Katz, move back to Dr. Katz, rather. He talks about this idea of how the kids are lying or they're not lying and how you can tell if they're lying. But doesn't the collective experience, given the pre-scandal that rocked this country just months ago and still pervades, doesn't that enter into the assessment that these jurors are going to make?
Well, it might, but what's perfect about a witness like this, at least for me, and Mr. Mesereau and I have different styles, when you ask a witness a question like, if you don't have any physical evidence, doesn't it pretty much become a subjective determination about credibility, correct? And they don't answer it yes or no. They go on with an answer like this doctor did.
You got to get that yes or no answer.
You grab him right by the tie, bring him back and say, answer my question,
Answer my
doctor.
question. And I'm going to leave my tie in place for now. When we return, the attorneys kiss and make up. All right, that is my April Fool's joke for the day. Stay with us.
I love that.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Defense attorney Tom Mesereau continues to grill the lawyer who represents the family of the accuser. And yes, the Mark Garagos mentioned in the upcoming testimony is the attorney of Scott Peterson infamy and the attorney who also first represented Michael Jackson on this very case. Here's what the jurors heard according to the courtroom transcripts.
You wrote a letter to Mr. Garagos on April 3rd, 2003, correct?
Yes.
In that letter, you never mentioned anything about molestation, correct?
That's correct. The only purpose of the letter was to get the items that I had written about before.
In the April 3rd letter, 2003, you mentioned nothing about alcohol, correct?
That's correct.
You mentioned nothing about false imprisonment, correct?
Correct.
You mentioned nothing about any alleged kidnapping, correct?
That is correct.
You mentioned nothing about any alleged extortion, correct?
Correct.
And as of April 3rd, 2003, you have never called the police on behalf of the correct?
Not correct.
You didn't call the police to report false imprisonment, molestation, or extortion?
That's not what you asked. You asked if I had ever called the police.
When did you call the police?
I was interested to find out what was happening with the investigation, and I called, I guess it was the sheriff's office, spoke to, I don't know. I know I called. I don't know if I spoke to Sergeant Robel.
Not during this time period, sir.
No, I never called the police to report anything about the...
All right, Howard, we're back to this issue again, the idea of who do you call, the police or the lawyer, when something like this happens?
Not Ghostbusters, that's
Not
for sure.
exactly.
Well, here's the answer. You call the lawyer if you're looking to get money one day. You call the police if you're looking for justice because your kid has been abused and falsely imprisoned.
One of the things that's really interesting about this false imprisonment count is we have a number of people who are reported to. We have Louise Palanker, we have Jamie Masada, then eventually we get to Dickerman, but they claim that they heard this woman, the mother, say, I'm being held against my will, I can't get out of Neverland, that she sounded frightened in her voice, but somehow no one calls the police.
Now, is that really, especially with respect to calling the lawyer before you call the cops, is that really a fair indictment? I know you all will say yes, defense attorneys that you are.
I won't say yes at all.
Because look, I mean, but let's be realistic though. If you don't know what to do, if you've never been through this kind of process before, and you're dealing with a megastar, someone who has lots of money in a culture where money walks, we've seen individuals get off because of their money, and I'm not talking about O.J., but isn't that a logical thing to do because you don't know what you're dealing with?
It's very logical, and it's logical even with people without celebrity and without money. And I'm sure we have all had the situation where the phone has rung and someone says, I'm in trouble, or I know someone who's in trouble, and I don't know what to do, and I need to talk to you. In the first place, they come as the lawyer. The interesting thing here is, if they go to Dickerman, they may not know that Dickerman has any relationship with Feldman, but they certainly know who Feldman is.
And Dickerman certainly knows Feldman, and there's a connection all the way down the line throughout this trial to Feldman, isn't there?
Dickerman, Feldman, Katz, Sneddon, lots of money.
And will the jury make that? And it's going to be bad news if they do, don't you think? You can say something. It's okay. Watch our exclusive Michael Jackson trial coverage, the weekend wrap-up show, tomorrow at 10 and 4. Next week, folks, we move to 7:30. Back there. We'll see you. Leonie.